Thank you, Mr. Chairman. Welcome to each of the witnesses. Our founders included in the United States Constitution the protection not just of property rights, but also specifically of intellectual property rights. Article 1, Section 8 makes clear Congress's duty to ensure the exclusive right of inventors. In fact, the word right only appears in the Constitution in two places. First, and forgettably, in a subject heading describing the rights of members of Congress. The second place it appears is in the context of patents, specifically that the Constitution guarantees the rights of authors and inventors to secure the benefits of their writings and inventions. I have some concerns when those rights, which often amount to a person's livelihood, can be stripped away by unaccountable bureaucrats, not elected, nor appointed by the President, nor confirmed by Congress. I know that my colleagues have been working hard on the PTAB Reform Act, and I applaud them for their efforts. I'm sure they would agree that their bill is an important one. And as such, I would hope they would likewise agree that any bill that would significantly alter the patent landscape, affecting billions and billions of dollars a year and implicating America's national competitiveness and maybe even our national security, should be entitled to a full and fair markup hearing. Not a truncated, lightly attended hearing, but a full markup hearing by the full committee. When the stakes are so high, as they are in the context of billion-dollar patents, the cost of unintended consequences could be disastrous, not just for inventors and companies, but for America. And so I would urge my colleagues on the Judiciary Committee, particularly Chairman Durbin and Ranking Member Grassley, to schedule a markup hearing on this bill for the full committee. I do have significant concerns with PTAB itself. Its origins are somewhat suspect. Google, which enjoyed an amazingly cozy relationship with the Obama White House, sent their deputy counsel and their head of patent strategy, Michelle Lee, to head the PTO and establish PTAB. Interestingly, PTAB became a very friendly forum for Google and other big tech firms to challenge the rights of inventors. For example, in 2020, PTAB found 84% of the patents it fully reviewed to be invalid. And many patent owners that successfully defend their patents against big tech in district court are immediately dragged before PTAB, where they have to defend it anew. Big tech obviously loves PTAB. 18 of the top 20 filers in PTAB are big tech. Out of the PTAB petitions filed by the top 10 petitioners during 2021, Samsung, Apple, Google, Intel, and Microsoft collectively accounted for 81% of all such petitions. But it isn't just big tech that loves PTAB. China has also found PTAB is a useful tool towards invalidating American patents. Chinese companies such as ZTE and Huawei are prolific petitioners at PTAB. Again, the risks of getting this wrong are severe. If this bill should move forward, let's do so under the full light of day, subject to a full and fair markup hearing. The American people deserve no less. And Mr. Giles, I want to ask you a couple of specific questions. Number one, do you agree with what I just said, which is the consequences of changing this system are significant and should be considered carefully for unintended consequences?
Yes, I fully agree with that. The consequences of disturbing the patent system are real, and they could have a tremendous effect on the United States economy and national security.
So you also urge the passage of the Stronger Patents Act. In your judgment, how would this act ensure fair proceedings?
So there are many ways listed in the...
Apparently the patent on the microphone has expired.
So we can work on the communication technology here. Okay, so there are a number of things laid out in the Stronger Patents Act. One is increasing the burden of proof for PTAB proceedings. Another is limiting the number of proceedings that a petitioner could bring. You can't bring subsequent proceedings. You can't bring multiple proceedings at the PTAB to serially attack and to continue to attack patent rights and put smaller companies at a disadvantage. And there are a whole number of other protections laid out in the Stronger Patents Act.
Thank you.